We're joined by the trial attorney Misty Marris right now. So welcome, Misty. As always, as former federal prosecutor David Weinstein is also with us. Hello, David. Misty, you first on the defense, which Laura went through there, this whole idea of not so much a chokehold, but a civilian restraint, which there was one of the points they were trying to make earlier. What about the defense that was put up here for Daniel Penny?
Yeah, not surprised they're making that argument because remember, causation is a central issue for the defense in this case. First, they had a medical expert talk about how the chokehold itself did not cause the death of Jordan Neely, but it went further than that. If you recall, the person that trained Daniel Penny took the stand and said that actually Daniel Penny did not administer a chokehold that was in line with what he was trained to do, and that the defense continued to argue throughout the case that he wasn't putting enough pressure on Neely to make him pass out, much less kill him. Now, we heard that come full circle in today's closing argument, where they recharacterized the idea of what is a chokehold versus a restraint. And the defense attorney in closing went so far as to say that Daniel Penny did not administer this the chokehold or the civil restraint in the way he was trained, because he did not want to cause Jordan Neely to pass out. So it feeds into that argument about the pressure that was exerted and why it was reasonable and justifiable from the defense perspective.
Now, from the prosecution side, David, they say they're going to need 4 hours to go through the closing argument. What's their best case to prove this beyond a reasonable doubt that indeed it was manslaughter?
Well, Connell, they're going to focus on intent, on negligence, on whether or not he should have reasonably believed what he was doing was going to cause this individual to die, whether or not the presence of these drugs in his system had anything to do with it, and that his intent was not to just protect the people on the train, but once it got past that point, that he continued to apply this maneuver, and that's what caused the death of this individual. And it was not simply that he was trying to protect the other people on the train, less of a case of he didn't do this in a fashion that necessarily was premeditated. We're not talking about Bernie Getz here. He didn't go out with a gun and try to attack these people. You know, his defense, as Misty pointed out, is that he was trying to keep this individual from hurting anybody else on the train. So the prosecution has to counter that by saying he did that to a certain point, and then he used reckless disregard for the health and the safety of this individual. He didn't need to continue to apply the chokehold, and that's why their medical examiner's testimony about what the cause of death was is going to be so critical to the prosecution's case.
Bernie Getz, of course, the famous subway shooter here in New York City way back in the 80s. I want to ask both of you, while we have you, about the pardon that's been issued by President Biden of his son Hunter as well. We've talked about the politics already of it, the fact that the president said he wouldn't do it and it still went ahead with it. It's full and it's unconditional. So, David, you first on the power of presidential pardons. This is from the Congressional Research Service. There are two textual limitations on the pardon powers exercised. First, the president may grant pardons only for federal criminal offenses. Second, impeachment convictions are not pardonable. The court has also recognized some other narrow restraints, including that a pardon cannot be issued to cover up crimes prior to commission. So, you know, but generally speaking, this is a widespread sweeping power, and this is about as sweeping of a pardon as can be issued, right? David, what are your thoughts on it? And maybe you could go over, as a federal prosecutor or former federal prosecutor, the pros and cons of this, the idea that the president has this much power.
Well, Connell, you're right on both accounts. This is one of the most powerful things that a president can do. And the only limits are you can't pardon somebody for a future crime, and you have to be specific about what you did. And that's what he's done here. He's a father, so I'm not surprised he did it. From my perspective as a former federal prosecutor, he talked about a couple of reasons why he was doing this and what the effect might be. And it's his spin on it. His belief was that his son should have been allowed to go into a diversion program for both the gun count and the tax count, and that these types of cases very rarely, if it ever, reach the courts. So by him pardoning him, he's putting him in a position, if he was a regular person, somebody would have received diversion, and then he would have been allowed to have these crimes erased from his record. And so, you know, the long-lasting effect is not necessarily going to be for President Biden and for his son, but rather, how is a future president going to do this? We see it time and time again at the end of every president's term, the pardons and clemencies that they put in place. So
Absolutely.
what is it going to do for the future? What will the now incoming president do with any pardons he has at his disposal?
What about the arguments, Misty, just in terms of the pros and cons of it, from your point of view? I mean, just looking at something like this over the years, to David's point, we had a Democratic congressman on earlier, Steve Cohen, who said he had a constitutional amendment that he's proposed to say that you shouldn't be able to pardon your family members and that kind of thing. And, he said Republicans didn't support that, but he said that's what he's introduced. What about this idea that the president can, whether it's Biden or anybody else, can basically do whatever they want in these situations?
Yeah, I mean, it's written into the Constitution, Connell, and really this pardon by Biden today really mirrored the language that we saw with Gerald Ford pardoning Richard Nixon for crimes that he was not indicted. And look, Biden had a choice to make. He chose a very, very broad pardon that spans from 2014 to 2024, goes beyond the years of the alleged conduct of the two criminal cases that Hunter Biden was facing. And he also, instead of a pardon where you erase the conviction, he could have gone for clemency, which would mean no jail sentence. So there were other options there to make it more narrow. He chose the more broad choice, the most broad choice. However, that is a constitutional power that is yet to be limited. And so as it stands today, this is something that is acceptable from the legal perspective. What it means from the public perception perspective or politics, that's a whole other story that I can't comment on.
Right. Well, we have plenty of people who have all day. Everybody's got something to say about it. David, thank you. Misty as well. More to come.